Excellent. Thank you for letting me know that. Great. Thank you. All right, so let's get started. I am Bobby Fazy. I am an estate and business planning attorney, and I'm president of Insight Law. I'd say our practice is devoted about 60 to 70% to just doing estate planning and 30 to 40% business planning. These are the questions. The sheet that I've got up here, let me make sure it's showing. These are the questions that I would be asking an attorney, knowing what I know. Everyone asks about price when going in and trying to figure out how to approach estate planning. That's a very important question. There's about 14 other questions you should be asking. And so I'll go through our program today, and hopefully you'll understand why we're asking those questions. At least you'll know our answers. And my goal really is to educate you and just be a good consumer. So I'll check back in later and see how we do on that. And so with that being said, that's me again, Bobby. That's me in a suit, actually. But you'll find that I'm a very blunt attorney. Most estate plans just don't work. How would you know if your plan worked or not, right? Maybe when would you know might be a better question to ask. Maybe after you're gone, it might be too late. But my point today is, I don't want to take a legalist, like a formal legalese approach. I'm very practical. I'm a visual learner. And so the way that I approach the estate planning side of things, I call it the snapshot test. And let me make sure that my screen is showing up. And so the snapshot test looks like this. Basically, you have to visualize the time after you passed away and you're looking down from your cloud from above. All my clients look down, right? They don't look up. Beats the alternative. But if money's going where you thought that'd be going and people doing what you thought they'd be doing, that's generally a plan that works. Money not going where you thought they'd be going and things kind of a mess, probably a plan that didn't work. And I find that people get caught up in these different types of traps that are out there. And so one trap I find is just focusing on the documents. The documents are important, but people focusing on, I need a will, I need a trust, I need a medical directive, financial power of attorney. We'll talk about all those things today to make sure that you understand what they mean. But I think if you look or just focus on the documents, it's a little bit short-sighted. And my analogy that I use with this pitfall is I'm a big fan of the show called The Fixer Uppers. It's Chip and Joanna. If you haven't seen the show, Chip and Joanna, they go around and remodel houses. And Joanna's the one who sits down with the clients and asks them about their goals, their vision. How do they want the kitchen to look and feel, the bedroom, those types of things. And Chip is the carpenter who comes in with the tools and implements. And my point of this is, if you've ever watched the show, if you ever had your house renovated, does anybody ask the carpenter or Chip what tools he's using? Right? And so the point of it is they want the end result. I want the kitchen to look and feel like this, right? Same thing with the estate planning. The lawyer's tools are our documents. What I think most people, after doing 50 administrations, and I mean 50 of my clients passing away, what I've realized is that the documents don't do the work, right? They don't jump off the shelf. That what the family needs typically is someone to help them, guide them through and navigate this process and make it as efficient and easy as possible, make life a little bit easier for the family during a difficult time. And so that's really kind of the approach that we take. It's the process that when someone calls us, we can let them know everything's in good order, just be with the family. When it's time to come in, we'll tell you exactly what you need to do to get through this issue or to get through that difficult time. So that's one trap, is just focusing on the documents. We'll definitely talk about that, okay? The other is just focusing on taxes. Hey, I don't have a large estate. I'm not subject to an estate tax. There's no need for planning. And so, again, that's short-sighted, I believe, because taxes are one issue, and taxes rear their head in different forms. There is something called the estate tax in the United States, where you not only tax on your income all during your lifetime, there's an excise tax of 40% if you go over a certain amount of assets. that asset amount right now is as high as it's ever been for the federal estate tax level. You have to die with more than $12,920,000 worth of assets for it having an estate tax. And if you are over that, good for you. But that tax is changing. That law changes because they never got that to be permanent. So that's going to be cut in half. And maybe that still doesn't apply to you. But there's other taxes that are involved with the estate planning world where people, a lot of my clients have retirement plans, IRAs, 401ks, TSP plans, 403B plans. I've seen every type of qualified retirement plan there is out there. And so the way you leave your assets, if you haven't paid taxes on those, right? If they're like a traditional account, an IRA account that you haven't converted to a Roth. And so they're embedded with tax issues, and they just passed this law called the Secure Act 2.0. Original law was passed in 2019, and the newer law was just passed in December of last year. That impacts all the retirement plans, okay? And so how would you know that that impacted your plan if you don't have someone that helps you? And if you have a lot of assets tied up in your retirement plans, you want to know the rules with regard to that. So taxes rear their head in different areas, or the transfer trap, where, hey, I just want to avoid probate, the court process after death. And probate is basically a government audit of your affairs when you pass away. They want to make sure all your debts are paid, accurate inventory of everything. All the heirs have to be notified and get their data fighted out in court. Completely avoidable if you do things right, okay? But that's not the only reason to do planning. There's a lot of other issues that are involved. I'm hoping today you'll see what you really, I think, is missing is just knowing all your options, being a good consumer, and working with a firm that will counsel you on the pros and cons of choosing various options and co-creating the plan. And so a lot of people just don't know their options and their snapshot of how they want things to go or how they see how things would be playing out is fuzzy. And so my goal, hopefully today, is to get that picture a little bit clearer for you, give you some ideas and things that we do on our end. We have a certain way of planning people's estates. It's the Insight Law way. We've been doing this process since 2007. I used to do estate planning the traditional way prior to 2007, where it was very little follow-up by the attorney. It was very transactional. You get some documents and you go talk to the attorney, and 1 or 2 meetings, you'd meet with them and you get some legal documents. And that was pretty much the end of the relationship. The attorney will send you what's called a closure letter after giving you some documents. Very little follow-up, very little education, things not titled right. You're going to find that assets, integrating all of your financial assets and real estate and the like is critical in the estate planning world. And then, many years go by and people come back and try to put all this stuff together. And I've realized this is not a good way to do planning because we're hoping we don't have to implement the plan when we meet the client. We want to make sure it can be handled over time. And so here's how we start. And this is one of the core kind of concepts is one of the first things I would ask my attorney is, how do you define estate planning? So you should know what you're getting into. What does estate planning mean? And I like this definition of estate planning. I think it covers all of the issues that you should be thinking about. I didn't come up with this definition. I'm an instructor for the National Network of Estate Planning Attorneys. There's about 100 of us across the U.S., but this has really kind of stood the test of time, and it covers the issues. Number one, part of the definition is I want to control my property while I'm alive and well, right? That makes sense. But then a plan for me and my loved ones if I become disabled, mental disability. So estate planning is not just death planning. We got to also plan for the contingency. Hopefully it never happens to you, okay? It happened to our family. Where there is someone who has a mental disability, okay? So control while healthy, plan for a mental disability, and then I want to give what I have to whom I want, when I want, in the way that I want, okay? And I find a lot of people don't know their options on the way they can leave their assets to their loved ones. I'll show you a couple ways you can do that today. All while assuring my wisdom is transferred along with the rest of my wealth. So we're trying to set the bar high. Not only we want to try pass on your material wealth, if there are some life lessons and values, this is the place to leave those. This is kind of the best place where the gift can be held with a note or some type of voice, the personal voice of the person leaving the gift. So our counseling philosophy really matches up with this planning pyramid. And the basic point of this slide is that we really want to work with clients. We'll start with the most important issues towards the base of the pyramid, everyone that comes through our door, and we work our way up. So we first want to get to know your specific situation, your hopes, fears, goals, concerns, and then we look at the family situation. Are you married or are you single? If you're married, do you have kids? If you have kids, are they minors or are they adults? Whole host of different issues for minor children than for adult children. And age doesn't necessarily equal experience with money. And so how are they with money? If they're married, how are their marriages? Strong, shaky? How do they get along with one another? Is there a special needs or health issue that we have to be considered, that we need to be aware of, right? And if you don't, if you're single, do you have kids, or do you have other beneficiaries? How do you define your family? And so those issues, once I understand the kind of the landscape, then we can show you different strategies to preserve wealth, expand wealth, and save taxes. Okay. And estate planning is one of those fields where if you do have a financial advisor, that is very beneficial, because we're talking about your family and all your money. So we want to make sure things are integrated right, and that we have resources to be able to move things efficiently. Not a requirement to have an advisor. It's just I find that those things work easier when I'm not dealing with an 800 number from Vanguard versus I'm talking to Joe Smith over there. So basically, the idea with this planning pyramid is you teach us about the family, we'll teach you about the law, and together we'll make the plan work. Okay. I'm a bullet point person. I'm very kind of linear on that. I think there's 4 keys to an effective estate plan. I get asked to review estate plans all the time, wills, trusts, and things. And I just find these are the things that if I can check all of these things off, then I can say, yep, you've got a good plan. You've thought through the issues. So the first key is, did this person get good personalized counseling, or is this some word process document, that they could have gotten off of LegalZoom, right? And so I'll give you some examples of those. And yes, I spelled counseling with 2 L's. I'm trying to make a point there where the attorney's advice is something more than just getting some biographical data from you, okay, and spitting out some forms. Number 2 is do they have proper asset ownership? Very common pitfall in the estate planning world is that things are improperly titled, and I'll give you some examples of that as well. But generally, there's only 3 ways you can own your assets, okay? In your individual name, jointly, and by contract. That's it, okay? And so the idea is you got to get a great set of instructions and make sure that your instructions actually apply to your assets. And some people get confused on the joint ownership and the contract side of things. And as long as you know your way around that, you can make things work really smoothly and efficiently. And then number 3 is a formal review process. Let's have an agreement to take a look at this every so often, because things change, okay? And I'll show you how we address that without having to, people hate hourly billing. And so we don't do that on this side. And so we'll show you our response to that. And it's, here you go. Here's our option. This is the way we do it. If you want to do it, great, you can come along. Number 4 is controlled transfer process. You probably wouldn't be here listening to me if you didn't care how things kind of played out with your estate, right? And so, you wanted some kind of certainty, some kind of peace of mind. And so the way I test people on that is I get very blunt with them. I say, okay, if you were to die today, how prepared is your family if something happens to you today? Right? That's about as black and white as we can make it. And what I mean by that is, would they have any idea what to do, how to do it, and how to pay for it? Okay, and so these issues, if they're covered, you got a good plan. There's 5 ways to plan out there. So let me educate you on the different ways you can plan. You can do no documents, okay, and I'll show you how you could do a estate plan with no legal documents and just title things. I don't recommend that approach, but that's one way to do it. Number 2 is you can do a will, a simple will, a last will and testament, okay, and a POA. So what is that? A last will and testament, most people know what that is, but if you don't, that's a legal document that only takes legal effect at your death, okay? The will doesn't give you any type of disability planning. It just says when you die, these are the things that you want to be distributed to these people. And it drives the family to court. So will equals probate. There's a slide I have on that. My engineers love formulas. And then the POA, we live in a world of acronyms. I'm sorry, in the estate planning world, I didn't come up with these. But a POA is a power of attorney. And there's 2 flavors of powers of attorney. There's a financial power of attorney, and there's healthcare powers of attorneys. The financial powers of attorney, as you might suspect, deal with your financial assets, okay? But there's two types of financial powers of attorneys in most jurisdictions. There's what's called a limited power of attorney and a general durable power of attorney. What's the difference, right? The limited power of attorney takes only legal effect after you've been determined to be disabled. A general durable power of attorney is effective when you sign it. You see the difference, okay? And so what's the best way, right? And so that's where you get counseling on. And then the healthcare power of attorney, a lot of jurisdictions have different names for it. Sometimes it's called an advanced medical directive. That's a legal document designating a healthcare agent to make decisions for you when you cannot communicate them to the doctor. Okay, and it's not just the end life decision, it's all those other decisions up to it. I call it the pull the plug decision. Everyone just thinks about that, but are we going to pull the plug so quick, or are we going to think about things a little bit? Let's wait before we do it, or maybe not. But let's have a discussion about those issues. The other way, and so it's a simple kind of will side of things, and that does drive the family to probate. And powers of attorneys, I don't think are a great way to do planning, because the financial institutions seem to be contesting them more and more, and they get more nervous about them. But again, this is just my experience with that. And then the third way is a will with testamentary trust and power of attorney. So think of this, stay with me, a last will and testament. A testamentary trust is one that's created after death and with court oversight, okay? Which I don't know why you do, but there you go. And then you have your powers of attorney, the same thing with your will. So same thing with probate, and you got the trust that's created after death with court oversight. The simple trust, I've seen these a lot. These are word process documents or things you get off of LegalZoom or very transactional attorneys who are not really following up with you on any of the information, how to work the trust and how to make it work. That's that. And then I call the modern approach, that's kind of what we kind of try to follow, is just a process that when something happens, we got the legal documents to match up with whatever your family goals are. And when the major life events occur, disability or death, right, that we've got that process to help the family through that time and have an efficient way of addressing all of those issues. The challenges that are out there that you got to kind of address with the different ways to plan are these, okay? And I already hinted, mental disability is probably the biggest challenge, right, today. And because, to be blunt, when you pass away, right, we don't have to figure out what to do with the body, right? The disability, we had to figure out where you're going to be, what kind of care you're going to get, where's the money coming from, right? Who's doing that? Who's coordinating all of that, right? A lot more issues to deal with on mental disability, a lot more expensive. Asset transfer on death, how to get that done efficiently without getting assets frozen or held up. How do we do that so it's smooth? Taxation, let's minimize that to the greatest extent possible, of course. And then let's make sure that we're addressing personal planning goals, like what we want to happen to the money. Do we want to protect the money and make sure it's being used wisely or not? On that side. So our approach is a three-step approach. And like I told you before, we moved to this approach in 2007. So we've got about 16 years under our belt with this. So we've learned a lot on this process, right? And you're getting the benefit of that. But the Insight Law way is we just use a three-step approach, is that we develop the plan, step one. We call it empowering the design by developing the plan with counseling-oriented planning partners, which means people that are going to sit down with you and say, okay, this is your specific situation. Here are the pros and cons on each of these different options, and help decide which is the best strategy to go to, right? And then partners, meaning that if you do have a financial advisor, I want to make sure that I'm coordinating with them, or a trusted tax advisor, that we're all on the same page, right? And then empowering your legacy by having that maintenance plan, having a way to update the plan routinely and consistently. So that's step two, is committing yourself and your family to a formal maintenance and education program. I'll show you what that looks like on our end. So that when something does happen, we can empower that inheritance by securing appropriate assistance to transfer your wisdom along with the rest of your wealth, right? That's where I'm looking at the whole picture, right? I'm beginning with the end in mind. I want to get that family through that difficult time in the best possible manner. So that's a three-step approach, okay? It's not, hey, here's some documents, boom, we're going to go find the next client, and we'll figure something out down the line. Hopefully it'll work out. right? That's not the way we do it here. And so if your only goal is to avoid probate, here are the things that you have to be kind of thinking about. And I'll show you how to probate, how to deal with that, or how to avoid it without any legal documents. So first, you got to have the initial formulas. And I told you, anything that you own in your individual name at death equals a will equals probate. Okay, so that's controlling the probate process, is how you have things titled, and everything in your individual name goes through the probate process. So how do you avoid that? Well, you can title everything that you own as jointly, joint tenancy with right of survivorship. What does that mean? That's a joint account, right? You're probably familiar with that, where when one joint owner dies, the asset by operation of law will go to the surviving joint owner. It avoids probate process. Great, you avoided probate. Well, let's play this out in real life, okay? Let's say they have Bill and Mary Sample, my favorite couple, right? And they have their 2 kids. And so they title everything jointly, right? Bill and Mary. And I always have the Bill check out first. It's just statistics. Usually the males will check out first. And so when Bill passes away, everything goes into Mary's name. Mary didn't have to go through probate. Great. All right, so now what? Everything's in Mary's individual name. So now that Mary's in the grieving process, we want to burden her with figuring out how to organize all the affairs for the kids, because it's going to go through probate, right? And if you think you're just going to add the kids on as the joint account owners, think again, all right? Because when you are a joint account owner, there's 2 things. It's legal ownership. They are owners. They can do whatever they want with the money. And maybe, hey, we trust them. But you also take on all their baggage. If they get divorced, guess what? That's part of the divorce proceeding. They get sued. That's part of the credit. That's a fair game asset. Not a good way to do the estate planning side of it. Let's just do it right up front. Get it done so that we don't have to worry about that, right? The surviving spouse can not have those issues burdening them. Transfer on death accounts or payable on death accounts. These are the financial institutions forms. And if I have my options of taking their trust account versus my trust account, guess who's going to have all the boilerplate language in their favor on theirs? And that's an account, and we do use it sometimes in limited circumstances. You give up some things, but we have to make concessions sometimes when we're dealing with various financial institutions, where you take the death certificate and you name beneficiaries on your accounts, okay? Third is planning with the box, and I call the box in quotes. These are like your beneficiary designation assets, things like your IRAs, your 401ks, life insurance, anything that you have to fill out that information in that box. Here's who's your beneficiary, primary, contingent. You got to make sure, especially with your retirement plans, because the laws have all changed, that you're writing the right thing in there, because there's huge tax implications with regards to that. Why wouldn't you want to get counsel to make sure you have thought about all those issues properly? Okay, so you can avoid it by doing things this way, but what are you giving up? And what I find what you're giving up is you're giving up a lot of your personal planning goals that I find out typically that people are interested in, okay? And so these are typical planning goals. These are not the exhaustive list, but I can give you an idea of what the issues that we see, that we come across. And so catastrophic illness protection, remarriage protection, creditor protection, divorce protection, and values promotion. So catastrophic illness protection, right? So on that catastrophic illness protection side, a lot of people think that they've done their disability planning because they have their healthcare power of attorney, which is, a healthcare power of attorney is important, and you should have that legal document, but it's just a legal document that designates a healthcare agent and gives them a list of powers, right? It says, you can check me into the hospital, you can check me into a nursing home, you can keep me home and bring home care in. You decide, healthcare agent. And my point is, if it's that important to you, what your wishes are, if you have an opinion on how you'd like to be taken care of and where, if you ever do have that catastrophic illness, where in your legal documents does it say that, right? Shouldn't we put that somewhere? So that's number one, and that's not in your healthcare power of attorney. You got to put that, and we have ways to put your goals and instructions in there. And if you don't care, right, you're not doing your family any favors, because that's the biggest burden possible that you have to that you're laying on them when you decide what kind of care I get, and that's a big burden to put on somebody. Okay, and so the questions that I find are: would you rather leave instructions for your own care? You really should. Okay, and then on the financial side, this is a tough one. It's a challenge. There's no perfect science, right? But having a strong process can help alleviate some of those concerns. Is when you determine when you give up control of your finances. My dad had this dementia, and it was caused by this disease called Lewy body disease. And it was like the first few years he was kind of still with it, but years 6 through 10 really impacted, and he was starting to get taken advantage of at the beginning part, where people would there were these phone scams, Apple Pay phone scams, and money was going in the wrong places. And I know, like, if he had all of his mental faculties, he would have never done those things. But there's people out there in the world that take advantage of you. Okay. And so the way that we try to approach this process, the way we approach it, is we ask 3 critical questions when it comes to disability planning on the financial side of things, right? And we want to look at these 3 questions: is when am I disabled? Okay. And I'll show you how that looks like. When am I disabled as you define it versus just some legal definition of it? And then, who do you trust managing your money when you are disabled? And what can they use the money for, right? When, who, what? Break it down. And the way that we do the when side of it is we use a personalized definition of disability where, yeah, you need a medical opinion, okay, but we also we call it a disability panel, where maybe we have a medical opinion, and if you're married, maybe the spouse is involved with that decision, or if you have other family members or friends that you trust on deciding, when can I no longer effectively manage my financial affairs? All right. And if that's triggered, as you define it, then a private transfer to someone you handpick that you trust, and you lay out what they can use the money for. And I'm not leaving you a blank piece of paper and say, give us what your instructions are. We've done this before. We've got checklists and like that you can work off of. I'm a big believer it's easier to edit than to create. If you are in a situation, this is not I'm not educating on Medicaid today and Medicaid planning, but this is just letting you know on the catastrophic illness planning, when someone is in a place where they have to go into a nursing home or need round-the-clock care, depending on your jurisdiction and then the Washington metropolitan area, that is not covered, right, by your health insurance. This is out of pocket, okay? Or you have long-term care insurance, which is very expensive, or have some other way to address that. But you're looking at anywhere from $6,000 a month to, I've seen $30,000 to $40,000 a month for this care. And that blows through people's retirements. And there's a way through planning, trust planning, where it's a last resort type of planning, where you basically divest yourself of assets and try to get qualified on the only government payer of long-term care services, which is called Medicaid. You have to be basically penniless. Not a good way, not a good option, right? It is an option. It's the last option usually, okay? But we have to understand that those are options out there. Remarriage protection, I don't know why, and I don't spend too much time on this, on the remarriage protection side, but it's not about trust between the current married couple. It's about that new person, right? And so let's say I have a Bill and Mary sample, right? My favorite cast of characters, and they have 2 kids. And let's say that Bill and Mary have the I love you wills. Very common, right? The I love you wills basically say when Bill dies, everything goes to Mary. When Mary dies, everything goes to the kids. And if Mary predeceased Bill, goes the other way. Very common, right? So let's play this out of the remarriage context. And so Bill dies, everything goes to Mary. When Mary she goes down to the tennis club, right, and meets Bo, the tennis pro, and they fall in love, and she gets remarried. And let's say that she doesn't cooperate, and she predeceases Bo, right? But her will says everything goes down to my kids. Even though Mary's will says everything goes down to the kids, does Bo have a legal right to the assets? Absolutely. He could say he's a spouse. I said, I don't care what the will says. I'm taking my statutory rights, and every state has different statutes, but it's anywhere from a third to a half, maybe even more, depending on length of marriage and which jurisdiction you're in, right? And so, okay, that's one issue. And then the other issue is, if you are taking notes, one key concept is that title will trump the legal documents. What does that mean? The way things are titled will trump how the will and other legal documents, the instructions are in there. So let's look at an IRA. Right, in a married couple situation, but Mary's married to Bo. Who's usually the beneficiary of an IRA in a married couple situation? The spouse, right? So if Bo's listed on there, the custodian of the IRA doesn't look at the will. They look at the paperwork, and they're going to give the money to Bo. How do most married couples have their assets titled? Jointly, right? With that thing called survivorship I told you about. If it's jointly held, it doesn't go through the will. It's going directly to the surviving joint owner. Who's usually the life insurance beneficiary? Spouse. So not saying that it may be, but someone's got to check to make sure that we've got everything in line, right? So if there was a way that Bill could leave his assets to Mary and she could use it for whatever she wanted during, her life, but it had to go down to the kids when she passed away, is that something that's worth spending some time talking about? Right? Is that counseling? Is that word processing? You kind of get an idea. We're just trying to figure out what's important and just cover those issues, just head them off at the pass. Creditor protection, a lot of people, this is probably one of the main stories in my firm on the creditor side of things. And so I use my school bus story as the example to explain creditor protection. And it goes like this. So let's say I'll use myself as the, I'll be the person. So let's say I've died and there's two assumptions. So let's say I'm dead in the story and there's no creditor protection for me while I'm alive. All right, so let's say that when I pass away, after I pass away, let's say my spouse is all distraught, driving on the road, doesn't pay attention, got the daughter in the back making noise. She runs a red light, bam, hits a school bus full of kids. Let's say horrible facts. Let's say one of the kids dies. She hates herself. The world's against her. I don't have enough money in my estate or insurance to cover for hurt and killed school children, right? Catastrophic creditors. That's my only point, right? Some people say just say make it a school bus full of lawyers. That'll make things go a lot easier with the clients. But the point is that, right? You have these creditors out there, and there's a couple of different ways I could have left my assets to my loved ones. Okay, and I'll go through them. So the first way I could have done it is through a simple will. Remember I told you simple will. I leave everything outright. Let's say I left everything outright to my spouse. My spouse receives everything outright. They hit the school bus. All those things I left to her outright are subject to her creditors. All right. Option two, I could have titled everything jointly. Remember that thing called survivorship. So all those assets are outright in her name, gone. Okay. Things that, maybe the house that had equity in it, the lien is gone. They can put a lien on the house. They can take bank garnishments on the accounts. Those are gone. What about contracts? Let's say I have a life insurance policy that's not worth a lot when I'm alive, but turns into $1 million. I put my spouse's name right there. She puts it into her account. She hits the school bus, gone. Fourth way is by a simple trust. I've seen these plans, very common, very boilerplate, and it says when I die, everything goes outright to the spouse. Same problem. It's going to be subject to the creditor. So let's try to think through this again. Let me pull myself out of the grave and try to do it a different way. Okay, what if I did it this way, where I could leave my assets to my loved ones. They can use it for whatever they wanted, but if they hit the school bus, it's protected from their later creditors. Let me say that one again, okay? I can leave my assets to my loved ones. They can use it for what they want, but if they hit the school bus, it's protected from their creditors. So I want you to kind of connect the dots. Remember that definition of estate planning where I said, I want to give what I have to whom I want, when I want, in the way that I want. So I'm zooming in there on the way that I want. How many of you would like to leave your assets to your loved ones protected from their later creditors? Right? And how many of you have been asked that question before? And is that counseling or word processing? Okay. And so it's about trust law. So let me tell you some basics on a trust and a lot of misinformation. I use some visuals here. So think of a revocable trust as just an open box. Okay. You can get in and out of it. Your creditors can. So just by creating a revocable trust during your lifetime, you're not going to shield your assets against creditors. Okay. That's a different story. but when you pass away, you can put the lid over it and say, this is my hard-earned wealth for my beneficiaries. It's for them. It's not for their creditors. It's not for their ex-spouses. And even a bigger one, it's not for Medicaid to require spend down. Okay, it can supplement their care, but they can't make them spend it down. And so with their money, you can do whatever you want. I'm just leaving my money in a nice little bow for them. Right. And so that is a big, powerful benefit of trust. And you can leave things to people that way. OK, whether you want to do it or not, that's up to you. But a lot of our clients like that. And then how many, for divorce protection, I don't spend too much time on it. How many of you would like to agree that the assets that you leave to your beneficiaries stays with them and doesn't go with who I call as a new outlaw, right? It's kind of like the same thing with the creditor. It's a different form of creditor. Values promotion, like I told you, this is the best place to leave like some type of a personal touch when you make this final gift, right? And I use the babysitter story. It's a simple example. If you ever hired a babysitter, I have a 7-year-old, and the first time we hired a babysitter, right? Well, one of us was giving her all the instructions, saying, okay, well, she's going to want to stay up late. If you read a book to her, read every page, because if you skip a page, she knows. I don't know how she knows. She's not going to want to brush her teeth. Our neighbor's information is here. Here's our cell phone. We're going to be here, right? And so you get the idea is that we're leaving all these instructions and we're just going away for just one evening for a dinner and a show, right? And so my point is simple, right? Would you agree that we leave more instructions for our loved ones when they're little and we're just going away for an evening for a dinner and a show than we even think about leaving in our estate plans when we're going away for a lifetime, right? And so I'm not giving you a blank piece of paper and say, give me your values. If we find different opportunities, we'll raise those to you and say, hey, this would be a good place to do something like this. So I look at it as like kind of the trip to the eye doctor, where we're kind of narrowing things down. Which one do you like better, 1 or 2, right? When you're looking at although I'm always guessing on those, but you get the idea, is that we're trying to give you some good concrete options and develop the plan with you. So that's kind of giving you an idea of the setting up of the plan, counseling, kind of on that side. And then number 2, once we set the plan up, that's the heavy lifting. Now let's commit yourself and your family to a continuing maintenance and education program. And early on in my career, I used to focus on let's focus. People really need to keep their plan updated because there's changes in your life, your personal situation, your health situation is going to change potentially, your financial situation, the laws I know change. But people, I didn't get that. But what they weren't wanted to do was pay us additional like hourly billing. I was like, okay, let's focus on what the real issue is, and let's talk about that and just get that off the table. So this is what we do on our side: is we have a maintenance plan, okay, and it's optional. First year is not optional. You got to be, that's part of the initial package, and then if you want to drop off after the first year, you can. No one does, but you're welcome to. And so we charge $995 a year. And what do you get that for the maintenance plan? I am not going to nickel and dime you for phone calls, emails, and faxes. You got a question, call us. The way we do it is by scheduling phone appointments. I've got certain dedicated slots throughout the week. So I'm not playing phone tag. It's a very organized way of doing it, okay? Copies, word processing amendments, that's part of the deal. This next one is probably the most important and probably justifies itself, the maintenance side of things. The fee on that is annual funding double check and ongoing funding support. What the heck is that? And you need to know what this is if you're going to go and create a trust, okay? And most people don't know what funding means in the trust arena, okay? Like I told you, there's certain kind of language that we live in the estate planning world. I didn't make it up, okay? But I'm going to teach you about it and how you can navigate it. So this asset review report is what we use for all our clients. And when we initially set up the plan, this is basically an estate inventory report, where if you got hit by the bus, I don't have to play Sherlock Holmes to go find everything. I hit a button, I know where everything is at, and we can handle the estate, because we're looking at, our mission is clear. It's like we want the plan to work. So we got to know where this stuff is at. And most trusts are not funded. What does that mean? It means that things are not titled properly, either in the trust or to the trust. Why is that important? If you created a trust and you don't have things attached to it in some way, then those assets will go through the probate process, okay? If you have one asset, is likely to go through the probate process. So one of the benefits of a trust is that you can completely avoid the probate process if it's done right. But the number one pitfall is people don't ever get all their assets in the trust, okay? And usually the attorneys will leave it to them. And because it's time consuming and tedious to fill out all the various forms for the various financial institutions, and they keep changing the forms, okay? And so we manage that process here, okay? And so that's part of the initial setup. And I'm going to tell you right now, that we have today. I'm going to give you the ranges of the fees, and you get a good idea of what you'll pay. The idea, but if you have 16 individual stocks at Computershare or savings bonds, we're going to talk, okay? And you're either going to fund them. We're going to work out some type of plan to do that. We know which assets and which financial institutions are hard to deal with, okay? And we want the plan to work. So we're going to evaluate that before we give you your exact quote, but that's kind of like we are looking at the nuts and bolts and actually the forms in the various financial institutions. Because once we get those forms set up right, it's titled by a trust, we have a much, we don't have to go through court, and we can do a lot of the paperwork and get things administered in our back office. We are the court, okay? That's why it's so important. So this report we send to you every year, right? And we ask you to update the report, give us the new values. And the check mark means we've got a piece of paper in the file verifying that it's right, that it's title right. And if there's a comment, why isn't this Apple stock in there? So we're following up every year with you, okay? And we want to make sure that we get the plan right, but you got to help us help you do the report. And if you buy something new, you buy a new piece of property, open up a new account, guess what? We'll help you coordinate the titling so it's done up front the right way in day one. Very powerful type of very powerful planning there. Okay, so let me get back to the sheet. That's what the annual funding double check and ongoing funding support is. Okay, and when you hear something, well, I'll say, hey, is the trust fully funded? Okay, that's one of the first questions I would ask somebody who asks to come to our system if they had their existing trust. If they don't know what I'm talking about, that's a big problem. And number two, let me see verifications. I've never seen it. No one has ever given me something from some other firm where everything was fully funded, that was proper. So we always have to manage that because the stakes are high. Okay, one thing not title right, it's an all or nothing game for me. It's very clear. No additional charge. We will not charge for a family meeting, just one family meeting within 6 months of the signing meeting. Again, it comes from, we want the plan to work. I'll go as high level or as detailed as you want with whoever you want. It's usually your key people, that they know who we are, what the game plan is, what their role is. But every year we have an annual group client meeting. I do these in January and February. I do them through Zoom. And I talk about the state of the laws, what's going on, what they need to know, what you guys need to know, what's going on with the law firm, any techniques and things that are out there, and making sure we're checking on the titling and funding of the assets. Every 3 years, we update your legal documents, okay? And so we're thinking on that side to extending that based off of just changes in the law. But the idea is that we have some consistent routine of updating the legal documents, and we do those in group format as well. And we're under, the first 3 or 4 years, we were still getting our processes down. We're in year 16 now. And so we have a pretty strong process and we can update very efficiently. Group educational programs on different topics. The most attended program is our trustee training program. This is, some people call it the 911 program. What to do when a loved one becomes disabled, what to do when a loved one passes away. Our client advisory board said, hey, Bobby, put it in big fonts and say required training and 911 info for beneficiaries. So I did this live every year, the Saturday before Thanksgiving. And then I put it up on video, put up on our website for video so that if you missed the live session that you can get to the other sessions, okay? And then let me go back. You can get the information is what I mean. All right, so then and then the other education program. So I get a lot of, there's a lot of people that are asking me about, I talked about in our annual client meeting, the Secure Act 2.0 and how that impacts retirement plans and how that integrates with trusts. And so I did a high level our annual client meeting and our client update programs, but we're going to do a special deep dive into that for those of you who like that stuff. So it's not like a requirement, but if people like that, I mean, I talk about the actual laws and we get into the nuances of that and how that impacts the plan. Other people not so much interested, but they say just make sure that you're on it. DocuBank membership is basically like having online medical directives. And so your online medical directives, like if you get into an accident, right, and you are you go to the hospital, you're probably not carrying your medical directives in your back pocket, but all of our clients get this card. It looks like this. And I tell people, sandwich that card between your driver's license and your health insurance card, because if you go to the doctor, they're going to know who you are, right? And if you can pay. And I've literally, if you've got the card, there's on the card, there's an 800 number that they can dial, and they'll fax or email it to the place, the healthcare provider, or you can just pull them down, or have your healthcare agent pull them down yourself. Okay. I just showed you how quickly I access mine. Also, with my dad, it would have been nice to have like a nice place organized with all of his medications. Not a legal requirement, just something that makes life easier for the family, or medical snapshot, whose doctors are, different doctors' histories and things like that are always helpful. So makes the plan stronger by able to, doing those types of those add-ons as part of the maintenance. And then digital executor services for your online accounts. Think about how many usernames and passwords you have. Not that I want any of your usernames or passwords, but the idea is that we have some type of plan to deal with your online accounts, your maybe your Amazon account, maybe your photos, emails. If you have a website, right? How do we make sure that those things don't get lost? Cryptocurrency, those things. Okay, so that is the kind of the benefits of the maintenance plan, and kind of give you an idea of that. And that's currently $995 a year. Okay, and I don't force anybody to renew. It's optional. Okay, but our renewal rate is basically 100%, maybe 99%, but very close to the 100% retention. So our maintenance plan, very simple for me. I have tools that make the plan work. The asset report, I know where things are at. Your personal the estate planning review worksheet. So we update your legal documents every 3 years, and our tool for that is we have an executive summary called an estate planning review worksheet that has the key provisions kind of pulled out of your plans, and you can very quickly make changes or know what your plan is all about in a 15 to 17 page document. Okay. Annual client meeting, client update, and then the family education and training. So that gives you an idea of the maintenance. Now, step 3 is secure appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. So we set the plan up. Now we've maintained it. Now the eventuality happens, right? So let's look at, how things work on death, right? And so I don't know what appropriate assistance looks like to you, but for us and our clients, it's about controlling costs. So we're definitely going to talk about fees now, okay? Full disclosure of the fees, and hopefully that'll give you true peace of mind. This is what they're doing, this is what they should expect, and this is the deal, okay? All right, so let me teach you about the fees. Okay, how do you control costs? Number one, I already told you about, is full funding. If I have a fully funded trust, that means everything is going to be controlled by the trust, and we're not going to go through court. If I don't have to go through court, there's still work to be done, and I'll explain how that works, but we're not on the court schedule, okay? In Loudoun County or Fairfax County, it takes 3 months just to get into the court. You can't even do anything with any of the assets till that time, right? If I have everything funded, it's 1 day to get everything managed, and we just prepare those legal documents, right? And so the full funding is a big deal, and that's one of our main things. We haven't had to we only had to go through probate once on one of our client cases, and that was because of an asset that was disclosed, that was not disclosed, and we discovered it late, and that was the issue, and they broke my perfect probate record, which made me mad, but you get the idea. It's the exception at our firm. So one of the questions I would be asking an attorney if I'm looking to hire them is, what percentage of your trust-based plans wind up ending up being probated, right? If you're going through a lot of probates and you're a trust attorney, there's something wrong. There's something, you shouldn't be going through probates really that much. Proactive trustee and beneficiary training. So I find that, just making sure that people who are next in line, knowing what their role is and what to do is key, right? And so that to me makes life easier and makes things go smoother. Proactive engagement approach. So on our side, if you're on our maintenance plan, when you pass away, we'll agree to do the administration at predetermined rates. We cannot lock your successors or your families into using us. We'll just be the cheapest people at that time to be able to manage that process, and we'll honor our rate for that, okay? But they don't have to use us. We're not locking anybody into using us. We have a certain way of doing it. We know what we're doing. And if you don't want to utilize that process, that's fine. I'm okay with that. All right, so that's controlling costs. Full disclosure of the cost. How do we charge? So this is the way the estate planning world works, okay, is that there's a cost of the initial counseling and the documents. So that's one. The cost of updating or failing to update. We have a maintenance plan. I showed you it's $995 a year. Most people don't update, okay? And then the cost after death. Most people don't look at the cost after death, but that's where it's all back end loaded, all right? And so let me show you the fine print, all right? So I'm just going to use some examples. This is Fairfax County. So if you have a will-based plan, right, and you go through probate, or you have a trust that is not fully funded and those assets are going through probate, here's what the attorney can charge to do the probate administration, okay? And people are like, what is fiduciary compensation schedules? Well, a lot of times they'll name a family member as the fiduciary. The family member has no idea what to do. They call the attorney will charge these rates. Now, do all attorneys charge these rates? No, some will charge less, some will charge more. If you charge more, you got to give the court a good reason, okay? So usually people are just right up on the edge of that, right? And so it's not, when you look at the fine print, it's like, oh, so while the assets are, and I'm just using Virginia on this one, Virginia is a reasonable compensation state. I love how they put it in quotes. But while the assets are tied up in probate, which could be years, 5% of the income receipts are a reasonable fee. So if you had $1 million CD, make it easy for me, that had a 5% interest rate, right? That is $50,000 of income each year. That is reasonable. And then a principal. So if you had the $1 million CD, right, the first 400,000, they could charge 5%. That's 20,000. The next 300,000, 4%. The next 3%, right? So a lot of people don't like those percentages when they actually see them. And then if you look at the other fine print, is that the commissioner may increase or decrease the compensation, right, in exceptional circumstances. So if it's really disorganized, the estate, then you have no chance on that. Oh, I don't think I showed you those. So let me make sure I showed that schedule. I didn't share my screen properly. So let me make sure it's up there. So this is the Virginia schedule with those percentages that I just went through. All right. Then the next schedule is Maryland. So Maryland, if you're in Montgomery County, Maryland, Loudoun County is the same. All the counties in Virginia are the same. Loudoun County, Montgomery County, Maryland, just to give you an example, there's the fine print right there. The attorney can charge 3.6% over anything over 20,000. They can charge 9% up to 20,000, but then that's to take care of them for the small probates. That's a lot of initial administration that they just. But that's 3.6% of everything over that is a reasonable fee. The attorney can charge for that to do the administration. Okay, let me show you some Florida statutes. So Florida statutes, I'm not suspecting that anybody is moving to Florida, although I got a lot of clients that are moving to Florida. But the point of this stat handout is twofold. One is there's two teaching points, and I guess I should back up. Florida has a strong senior lobby. Like there's a lot of seniors in Florida. I'm guessing people would agree with that if you could. And so some people call it God's waiting room, right? And so, so there's a lot of seniors there. And so Florida is one of the few states that put a cap on what an attorney can charge to do a trust administration. But just packed in a lot of stuff there. So let me break it down. A lot of people have the misunderstanding that if you do a trust, that when you die, there's no administration to be done and everything just happens magically for the family, right? That's not the case, okay? I'm going to be very blunt again. Death is a major life event. Every one of your relationships has to have closure to it, okay? Think about how many online accounts you have. Every financial relationship, every real estate, every business relation has to be tidied up and has to have a plan for that, okay? It's whether you're on the court schedule or not that the trust avoids that cost, okay? We still got to wind up your affairs, right? And so that's point one, is that there's going to be an administration on your death, okay? And then point two is Florida will give you gives you a good idea of what the market rate is, because there's such a strong senior consumer protection state. They're one of the few states that actually put a cap on. And it's all paragraph 3 here, and I'll boil it down. They basically said the attorney for a trust administration can charge 75% of what they could have charged on a normal probate. So you get a 25% discount, okay, for trust administration. And in Florida, I gave you the Florida probate schedule so you can see they're lower than most other jurisdictions. You saw 5% in Virginia and 3.6 in Maryland, 3% from 100 to 900,000, and then 2.5 from 1 to 3 million. And so you get an idea. It's on a percentage scale. All right. So let me show you how we do our fee ranges. Okay. And so these are ranges. I can't tell you exactly what I would charge you until I actually saw what your situation was. And I can promise you, you don't get charged anything until you know exactly the scope of work and what we're doing for you. All right. And so there's two options. Option one is most people take it. That's where, and I'll start with the administration fee, since we just talked about, how things work on death in the probate area and then the trust administration area, at least in Florida. So we're going to be below the 3%, 2.5% stuff. We're going to be 1.25%, like 30 to 40% lower on the administration. So we charge that, and it's only charged if we are hired, and that's at the administration. Okay. And why is that lower? It's because of the maintenance plan. Okay. Because that we're updating the plan, and I know the family is educated, and I know where the assets are at, and I know it's complying with the latest state laws and the like, and federal laws. I'm feeling good that I can offer that amount for the administration, and that's the $995 a year. Our setup fee for year one to get you set up on DocuBank, to get you set up on the digital executor services, get you set up on our portal, it's a little bit higher. We'll charge you $1,500 to get you set up on the maintenance, but then you're at $995 a year for renewals. The cost for setting up the plan, and typically for married couples and singles, it's going to be a trust-based plan. Trusts are the way to do the planning right now, as I talked about. I can put most protections in there. We're going to charge you 0.5% on the size of your net estate, subject to a minimum of $4,000 and a maximum of $13,500. Okay, where you land on that depends on your goals, your assets, and how things are. And again, if you have 10 stocks held at Computershare, we're going to talk. That fee's not going to apply to you, or you're going to have to do something on that, or listen to our recommendations if you want to work with us on that. Option two is it's a little bit lower up front. Our minimum is 1/3 of 1%. Our minimum is still $4,000. The maximum there is $12,000. The difference is we're going to charge you. You get a little bit of a discount up front. We're going to charge you 2% on the back end, only if we're used at that time. So that's our model. Most people take option one. I don't care which option you take, as long as you understand why we're charging it. And if you're comparing our fees to other people, be a good consumer. Ask them, what are you going to charge me to fund the trust? Are they going to fund it for you? Oh yeah, we'll do a deed for you to do the real estate. Are you going to charge me for a deed? Okay, well, what about my bank accounts? What about my investment accounts? What about my business interests? What about my life insurance, right? And so we got to look at what we're actually, you're getting, rather than some documents are like the base documents with little counseling. That's easy to do, okay? And so it's going that deeper part to make the plan actually work, putting the engine right together, the trust, and integrating everything together. On the back end is kind of my business model, and shows you how our revenues. I'm very transparent on how we do it, and so we have a very. I think a lot of people. You're probably thinking this. Some people, if you're not, I have a lot of engineer clients. They ask me, hey, Bobby, what if something happens to you, right? And so I have more people worried about my health and welfare than I ever had in my life. But my business model really lends to a succession plan. Right now, I have an external succession plan with another attorney. His name is Ed Clay. He's in your packets. And he's agreed to he teaches with me at the National Network of Estate Planning Attorneys. He's agreed to take over my clients if I get hit by the bus, and I've agreed to take over his, right? Until my internal succession plan is there. So we've got junior associates, but I think they're about 3 to 5 years away before we have, before they're up and ready to finalize that formal internal succession plan. And then the other question people ask me is that 995 fee, will it go up? Yes, it will go up some point. In 10 years, it's not going to be 995. But the last fee increase that we had was for $75, okay? And it happens maybe every 5 years or so. And so I'm just trying to keep up with inflation. And this is actually a loss leader, the maintenance plan, all the services that we're providing. But when we look into it, actually, we're getting a lot of client referrals from our existing clients. So that actually helps us if we're leveraging. We don't have to market as much, and we're getting the right people that follow, that like our system and our process. And then the initial counseling and design, we're not bringing on, I'm not what's called like the will mill, where I'm just trying to get in as many clients as possible. Our goal for this year is to bring in 60 clients and do really good job for those 60 clients, okay? We have a team of 10 here. We know our capacity, and we've got a really great team, and we're growing on that side. So that's how we set our fees. Again, you wouldn't be charged anything until we knew exactly what the scope was for you and what we would be doing. But that gives you a good idea of how it would be when you work with us. And so if you're looking around, I'd ask the attorney, I'm probably dating myself. I was a Paul Harvey fan. He was a radio announcer, and he always would say, "What's the rest of the story?" Right? I would ask, what are the rest of the fees for the attorney? Like, what are you going to charge me for trust settlement administration? And if they say they can't tell you, you say, here's my assets. I die tomorrow. The assets look like this. What are you going to charge my family? And you're probably not going to like, the answer on that side. Our disability process sidesteps a lot of issues and fees just by having a strong process on that. Death tax returns are becoming more and more necessary. Even though the estate tax exemptions are higher, there's something called portability, and our death tax return preparation is part of that fee, part of that deal. And portability basically is about, hey, if you have a big coupon, if there's a big federal coupon now, and you only have like a $2 million estate, and you had a $12 million coupon, when you pass away, do you want to port that coupon over to your surviving spouse with the idea that, hey, maybe the coupons come down or exemptions come down in the future? I don't know. That's a counseling issue that we go through with our clients when they pass away, the families when they pass away. Probate services, that's a trick question, right? How many of your trust-based plans wind up being probated? So if you're looking at fees as far as the overall traditional probate, I showed you those numbers were between 2.5% to 5%. Standard living trust planning, that's giving you those Florida schedules, gives you that 25% discount. For us, it's 1% to 2% for the entire life of the plan. It's just up to you, see where you see the value in it. And hopefully you get true peace of mind that this is what we do. And we've done 50 administrations, not we just started this. We know we have repetitions, we have a team. And so basically the idea is comparing traditional planning and the modern approach. The traditional planning is very basic documents and questions answered. That may be where you're at in life. Modern approach is so much more. It's the counseling, it's the funding, it's maintenance, it's updating. It's all those things under the iceberg that's out there. With that being said, let me check on how I did with those questions that I gave you, so you can kind of understand why we asked those questions, and then I'll conclude. Feel free to type in any questions that you want if you have any lingering questions while I go through this. So the first question, please tell me about your interest, background, and experience in the planning field. What percentage of your practice is in estate planning? So this is going to try to weed out those jacks of all trades. Like I told you, estate planning is hard enough where you just focus on that. We do estate and business planning. Those are just our core competencies. We're not doing personal injury, family law, litigation. That's not what we're doing. How do you define estate planning? I gave you our definition, right? And it's intuitive, but you have to think about it, right? It's control while healthy. Don't forget, plan for mental disability. If that happens, hopefully it never happens to you. But I want to give what I want to whom I want, when I want, in the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. What's your counseling philosophy? That's that planning pyramid. Get to know you before we start presenting strategies. What's your process for working with me? So I didn't show you my process chart. The process chart looks like this. And I find this process produces predictable results. You're here. It's about an hour and 15 minutes with me. There's no charge for it. The next meeting is a discovery dialogue. That would be with one of our paralegals or associate attorneys, where they'll, and no charge, they'll go over your personal information form. They will give you a goal exercise, and then they'll give you answer any questions, and then that they can answer, and then they'll give you a fee range. And then the initial interview is where we will give you a specific fee quote, scope of services, engagement letters, and decide whether to work together. If we decide to engage, then 1/2 of the design fee is due prior to the design meeting. And the design meeting is that trip to the eye doctor. That's anywhere from 2 to 4 hours. That's typically with me. I'll go through those issues with you. I would never keep you in a room more than 2 hours. Okay, we would break it up if we needed to. I never do that, but we go through those issues. I thoroughly make sure we counsel them the right way and go through the options. And then the delivery and review meeting is where we'll review the legal documents, make sure you understand them, sign, witness, formalize them. And then we want to do the financial strategy meeting, and that's where we want to make sure we have an accurate list of your assets. And so we have that asset review report prepared. And then we're going to make recommendations on how we would title things, and we're going to talk about it. If you have financial advisor, bring them on if you want. Tax advisors, whoever. We want to make sure we get the good thought process. And then once everyone is on board, then we'll bring all the magic forms, gather all those together to implement the plan, get everything in the right place. Optional family meeting is no additional charge as long as it's done within 6 months of signing the plan, where I'll go over the plan as high level or as detailed as you want with whoever you want. And then you're just on maintenance. The heavy lifting has been done up front, and there you go. So that's our process chart. And I just find it produces very predictable results for us. And so there you go. And then how will you counsel with me to design my plan? So hopefully you get an idea of the way that I do it. It's more stories, visuals. I can talk in legalese if you want me to, but most people don't. Here's an important question. How do we assure that my assets are controlled by my instructions contained in my planning documents, right? That's the funding question, right? Who's responsible for this coordination? You or me? That's important. There's a lot of money there on that side. How do we assure that my plan stays current with changes in the law? That's our maintenance plan for us. We're going to tell you what the updates and changes are. I know the laws are going to change January 1 of 2026, because that's when all the tax cuts are going to expire. How do we assure that my plan, what is the level of involvement of my family in the planning process? You know, this is obviously more involvement, transparency and communication is better. But I understand family dynamics too. And so we just got to make sure that we're being in tune with the family dynamics as well. How do you charge for services, right? And so specifically, how much will my estate be charged after I'm gone, right? What if I'm disabled? And so you want to make sure you ask those questions. And then if they're a living trust attorney, that's the trick question. What's your record with regard to probate? What percentage of your trust-based plans wind up having assets probated? We're like 50-1 on our side. Do you charge differently for those assets? Do you handle the filing of the death tax returns if they're necessary? Yes. If you do, how do you charge? That's part of our fee. What happens if something happens to you? That's my succession plan. How do I prepare for our consultation? Just complete the personal information form. Michelle will coordinate the time with you. How do I, what type of service should I expect from you? I'm a big believer in team approach. We've got a solid team, core team, and you're going to, you know, every step of the process, we've got the right people at the right place. Do you expect any commitments from me? I just expect you to respect our process and you know, our time. You say as far as appointments and completing the forms that we ask you to complete, we'll get the plan done for you. And then things you should be thinking about, whether, you know, on your own, hopefully got you thinking about things about what are my planning goals, what issues are most important for me, right? Who will fulfill the necessary helper roles? These are your backups. The helpers are, this is one thing you can't do yourself. My dad was a do-it-yourselfer, right? But, you know, if you're disabled or dead, you're not paying the bills anymore. So you got to figure out who are your backups, and we'll help you with that. You want to get a good candidate for that. And then do I have a current inventory of assets? That's important, right? We want to make sure we get that. What advisors can I involve in the planning process to more effectively design and implement my plan? Financial advisors are good. Sometimes tax advisors, it depends, how involved they are, if they're giving you planning advice or if it's more transactional. So those are the things to be thinking about. All right. And so with that being said, I will, be happy to take any questions that you have. And I'll hang out here for about a minute or so and be happy to, then I'll conclude. So it's been Bobby Fazy, president of Insight Law. And today we've been talking about estate planning. Hopefully you got some good information today. Thank you very much. And I got a question from somebody that said if they have their children, they're worried about their children who are going off to college. And yes, that is something. We have these college student packages that have some basic documents in place so that if something does happen to those kids, you are labeled down there as the healthcare agent. They'll call you, or the financial agent. Yes, we are able to provide those services. And so good question. And yeah, obviously those things would be addressed once we get into the discovery meeting. But yes, short answer, we could. Timing on that, I'm not sure on with regard to timing. We have to look at it, but if we're motivated, we might be able to do something expedited on that side of things. Very good question. All right, very good. Thank you, everyone. Hopefully have a good weekend. Again, let us know if there's any questions that you had. Hopefully you had got some good education today on the estate planning side. And Bobby Fazy, president of Insight Law. Thanks.